Good day, Dean, classmates. I will be reporting on the extent of liability, specifically on number one, recoverable damages. Second, stipulations of limiting liability. And lastly, limitations under the Montreal Convention. So first, recoverable damages. Damages is the pecuniary compensation, recompense, or satisfaction for an injury sustained, or as otherwise expressed, the pecuniary consequences which the law imposes for the breach of some duty or violation of some rights. Extent of recovery, contractual breach under Article 220 of the new Civil Code. So, carrier in good faith is liable only to pay for the damages that are natural and probable consequences of the breach of the obligation and which the parties have foreseen or could have reasonably foreseen at the time the obligation was constituted. While courier in bad faith or guilty of gross negligence are liable for all damages, whether the same can be foreseen or not. Those which may be reasonably attributed to the non-performance of the obligation. Note, the carrier, who may be compelled to pay, has the right of recourse against the employee who committed the negligent, willful, or fraudulent act. Kinds of damages. Under Article 2216, it provides that no proof of pecuniary loss is necessary in order that moral, nominal, temperate, liquidated, or exemplary damages may be adjudicated. The assessment of such damages, except liquidated ones, is left to the discretion of the court according to the circumstances of each case. However, proof of pecuniary loss is necessary if actual or compensatory damages are being claimed. So, first kind of damages, actual or compensatory damages, only for the pecuniary loss suffered by him as he has duly proved. Not only the value of the loss suffered, but also of the profits which the obligee failed to obtain. So there are two kinds. First is the loss of what a person already possesses or daño emergente. And the second, the failure to receive as a benefit that would have pertained to him or lucro cesante. It should be proven, cannot be decided based on the consideration of the judge, not to be based on the perception, observation, and consideration of the judge. With respect to restorative medical procedure, to be entitled to actual damage, you need to have an expert testimony. Without such, you cannot recover. Damages may be recovered under Article 2205 of the Civil Code. Number one, for loss or impairment of earning capacity in cases of temporary or permanent personal injury. And second, for injury to the plaintiff's business standing or commercial credit. So damages cannot be presumed. The burden of proof rests on the plaintiff who is claiming actual damages against the courier. In case of goods, the plaintiff is entitled to their value at the time of destruction. The award is the sum of money which the plaintiff would have to pay in the market for identical or essentially similar goods. For personal injury and even death, the claimant is entitled to all medical expenses as well as other reasonable expenses that he incurred to treat his or her relative's injury. And in case of death, the plaintiff is entitled to the amount that he spent during the wake and funeral of the deceased, but expenses after the burial are not compensable. Article 2206 of the Civil Code provides that death caused by crime or quasi-delict shall be at least 3,000 pesos. The amount now of fixed damage is 50,000 pesos. The defendant shall be liable for the loss of the earning capacity of the deceased. If the deceased is obliged to give support, recipient may demand support from the person causing the death of the for a period not exceeding 5 years. Spouse, legitimate and illegitimate descendant and descendants may demand moral damages for mental anguish by reason of the death of the deceased. Number one, loss of earning capacity. So net earning capacity is equals to the life expectancy times gross annual income less necessary living expenses. Life expectancy is two-thirds times 80 minus age at death, while net earnings is based on the gross income of the victim minus the necessary incidental living expenses which the victim would have incurred if he were alive, and amount of living expenses must be established. In the absence of proof, it is fixed at 50% of the gross income. Rules on loss of earning apply when the breach of the courier resulted in the plaintiff's permanent incapacity. Number two, attorney's fees. Refer to Article 2208 of the new Civil Code. Attorney's fees may be awarded in an action for breach of contract of carriage under paragraph 1, 2, 4, 5, 10, and 11 of Article 2208. If awarded exemplary, one is entitled to attorney's fees. So there are two kinds. First is ordinary or the compensation to the lawyer. Second is extraordinary or indemnity as a form of damages suffered due to the breach of contract. You can be awarded if you show that you were forced to litigate and when you are entitled to exemplary damage. But this award is subject to the discretion of the court. You cannot dictate, usually 10% to 15%. Number three, interest. 12% per annum if it constitutes a loan or forbearance of money, while 6% per annum if it does not. 12% for final judgment. Note, no interest, however, shall be adjudged on unliquidated claims for damages except when or until the demand can be established with reasonable certainty. The interest shall begin to run from the time the claim is made judicially or extrajudicially. Second kind of damages, moral damages. It includes physical suffering, mental anguish, fright, serious anxiety, besmirched reputation, wounded feelings, moral shock, social humiliation, and similar injury. Though incapable of pecuniary computation, moral damages may be recovered if they were the approximate result of the defendant's wrongful act or omission. So moral damages are not awarded to punish the defendant, but to compensate the victim. It may be recovered when there is death or there is malice or bad faith in transportation of passengers. So refer to Article 2219 and 2220 because it enumerates cases when moral damages may be awarded. So generally, no moral damages may be awarded where the breach of contract is not malicious. Moral damages may be awarded if the contractual negligence is considered gross negligence. It is, however, subject to three conditions in transportation law, namely death, second, malice or bad faith, and must be done in the performance of the contract of carriage, and lastly, physical injuries. The requisites. First, there must be an injury, whether physical, mental, or psychological, clearly sustained by the claimant. Second, there must be culpable act or omission factually established. Third, wrongful act or omission of the defendant is the proximate cause of the injury sustained by the claimant. And lastly, The award of damages is predicated on any of the cases stated in Article 2219. Factors to consider that could affect the amount to be recovered. Number one, the extent of humiliation may also determine the amount of moral damages that can be awarded. Number two, the extent of pain and suffering likewise determines the award. Third, official, political, social, and financial standing of the offended party and the business and financial position of the offender affect the amount of damages. And lastly, the age of the claimant. Third kind of damages is nominal damages, referred to Article 2221 up to 2223 of the Civil Code. It is adjudicated in order that the right of the plaintiff may be vindicated or recognized, and not for the purpose of indemnifying the plaintiff for any loss suffered by him. The assessment of nominal damages is left to the discretion of the court according to the circumstances of the case. The award of nominal damages is also justified in the absence of competent proof of the specific amount of actual damages suffered. It cannot coexist with actual damages. There is no loss in nominal damages, unlike in actual and temporate damages. Loss is present, which is proven and not proven, but rather ascertained by the court, respectively. In the case of Japan Airlines versus CA, the award of moral damages was justified because Japan Airlines failed to make necessary arrangement to transport the plaintiffs on the first available connecting flight to Manila. Only nominal damages were awarded in the absence of proof of actual damages. Fourth kind of damages, temperate or moderate damages. So it is more than nominal but less than compensatory damages. Article 2224 provides that it may be recovered when the court finds that some pecuniary loss has been suffered, but its amount cannot, from the nature of the case, be provided with certainty. It cannot coexist with actual damages. Definite proof of pecuniary loss cannot be offered, although the court is convinced that there has been such loss. Then the fifth kind is liquidated damages, which are those agreed by the parties to a contract to be paid in case of breach thereof. Ordinarily, the court cannot change the amount of liquidated damages agreed upon by the parties. However, Article 2227 of the Civil Code provides that liquidated damages, whether intended as indemnity or a penalty, shall be equitably reduced if they were iniquitous or unconscionable. Next kind of damages is exemplary or corrective damages. So the requisites for the awards of exemplary damages is number one. They may be imposed by way of example in addition to compensatory damages, and only after their claimant's right to them has been established. Number two, they cannot be recovered as a matter of right. Their determination depending upon the amount of compensatory damages that may be awarded to the claimant. And third, the act must be accompanied by bad faith or done in wanton, fraudulent, oppressive, or malevolent manner. Note, if gross negligence warrants the award of exemplary damages, with more reason is its imposition justified when the act performed is deliberate, malicious, and tainted with bad faith. The rationale behind exemplary or corrective damage is to provide an example or correction from public good. The award of exemplary damages in breach of contract of carriage is subject to the provisions under Articles 2232 up to 2235 of the Civil Code. In the case of Air France versus Rafael Carrascuso and CA, the inference of bad faith is there. It may be drawn from the facts and circumstances set forth therein. The contract was averred to establish the relationship or the relation between the parties. Deficiency in the complaint in stating that there was bad faith, if any, was cured by the evidence. In another case of Philippine Airlines Inc. versus CA, moral damages are recoverable in a breach of contract of carriage where the air carrier thought its agents acted fraudulently or in bad faith. The contract of air carriage generates a relation attended with public duty. Neglect or malfeasance of the carrier's employees naturally could give ground for an action for damages. Now for the second topic, the stipulations of limiting liability. Parties may not agree on limiting the carrier's liability except when provided by law. Parties may limit the carrier's liability provided it is not contrary to law, morals, or good custom. It is settled that in case of both cargoes and passengers, extraordinary diligence must be observed. Meaning of extraordinary diligence. In carriage of goods, the extraordinary diligence in the vigilance over the goods tendered for shipment requires the common carrier to know and to follow the required precaution for avoiding damage to or destruction of the goods entrusted to it for sale, carriage, and delivery. It requires the common carrier to render service with the greatest skill and foresight and to use all reasonable means to ascertain the nature and characteristics of the goods tendered for shipment and to exercise due care in the handling and storage, including such methods as their nature requires. In carriage of passengers, a common carrier is bound to carry passengers safely as far as human care and foresight can provide, using the utmost diligence of a very cautious person with due regard for all circumstances. So there are two circumstances here. First is when it is a gratuitous passenger, the common carrier limit liability but not for willful acts or gross negligence. And second is the accommodation passenger or passengers, only ordinary diligence is required to a common carrier. Question: can there be a valid stipulation lowering the liability or diligence to be observed? The answer: yes, but only applies to cargoes or goods. The following situations where the common carrier is not bound to observe extraordinary diligence. Number one, under Article 1744, a stipulation between the common carrier and the shipper or owner limiting the liability of the former for the loss, destruction, or deterioration of the goods to a degree less than extraordinary diligence shall be valid provided that it is in writing, signed by the shipper or the owner. Number two, it is supported by a valuable consideration other than the service rendered by the common carrier. And lastly, number three, reasonable, just, and not contrary to public policy. Note, the valuable consideration must be other than the services to be rendered by the common carrier. Exceptions: unreasonable stipulations. So under Article 1745, any of the following or similar stipulations shall be considered unreasonable, unjust, and contrary to public policy. Number one, that the goods are transported at the risk of the owner or shipper. Number two, that the common carrier will not be liable for any loss, destruction, or deterioration of the goods. And lastly, number three, that the common carrier need not observe any diligence in custody of the goods. Number four, that the common carrier shall exercise a degree of diligence less than that of a good father of a family or of a man of ordinary prudence in the vigilance over the movables transported. Number five, that the common carrier shall not be responsible for the acts or omissions of his or its employees. Number six, that the common carrier's liability for acts committed by thieves or of robbers who do not act with grave or irresistible threat, violence, or force is dispensed with or diminished. And lastly, number seven, that the common carrier is not responsible for the loss, destruction, or deterioration of goods on account of defective condition of the car, vehicle, ship, airplane, or other equipment used in the contract of carriage. Another situations where the common carrier is not bound to observe extraordinary diligence is when there is a stoppage in transitu. The common carrier in this case is bound to observe only ordinary diligence. Another situation is in a state of calamity. The common carrier has to exercise ordinary diligence before, during, and after the calamity in order that the common carrier may be exempted from liability for the loss, destruction, or deterioration of the goods. The same duty is incumbent upon the common carrier in case of act of public enemy referred to in Article 1734, number 2. Fourth situation is under Article 1742. Even if the loss, destruction, or deterioration of the goods should be caused by the character of the goods or the faulty nature of the packaging or of the containers, the common carrier must exercise due diligence to forestall or lessen the loss. Note, the common carrier in this case will not be liable if it exercises ordinary diligence to lessen the damage. It is only the act of transporting the cargo that the law requires extraordinary diligence. It is also important to note that Article 1752, even when there is an agreement limiting the liability of the common carrier in the vigilance over the goods, the common carrier is disputably presumed to have been negligent in case of their loss, destruction, or deterioration. Another question. Can the contracting parties stipulate validly that the common carrier exercise less than extraordinary diligence in case of passengers? The answer. The general rule is no. It cannot be validly stipulated that the common carrier will observe less than extraordinary diligence. However, there is an exemption. Under Article 1758, when a passenger is carried gratuitously, a stipulation limiting common carrier's liability for negligence is valid, but not for willful acts or gross negligence. Note, in case of gratuitous passengers, it can be stipulated that ordinary diligence can be observed, but not in the case of ordinary passengers. The lowering of the degree of diligence bound to be observed can never be stipulated. When there is only a reduction of fare, it is not a gratuitous passenger. In case of gross negligence or willful acts of the common carrier, the exception does not apply. The common carrier would still be liable. For the third topic, limitations under the Montreal Convention. Montreal Convention govern and may limit the liability of air carriers for death or bodily injury, for loss of or damage to baggage, and for delay. The Montreal Convention is an international treaty that came into force in 2003. It modernizes the rules of the Warsaw Convention of 1929. Some countries are party to both the Montreal Convention and the Warsaw Convention. Some are party only to one or the other, and others are party to neither. If a country has not ratified Montreal Convention, the Warsaw Convention may still apply. If a country has not ratified either the Montreal or the Warsaw Conventions, then no international treaty would apply and the carrier would establish its own limits of liability. On August 10, 2015, the Philippine Senate ratified the Convention for the Unification of Certain Rules for the International Carriage by Air, Montreal, 28 May 1999, or the MC-99. So this MC-99 is expected to come into force formally in the Philippines within the next year. The move is welcomed by the Airlines and International Air Transportation Association, or the IATA, who lobbied for the global ratification and adoption of the MC-99 to bring an end to the patchwork of liability regimes that continue to exist around the world. So where the Montreal Convention applies, the limits of liabilities are as follows. First, there are no financial limits for passengers' death or bodily injury. However, the carrier shall not be liable for damages exceeding 128,821 special drawing rights, or approximately 160,240 euro, if it provides that it was not negligent or at fault, or such damages is solely attributable to the negligence or fault of the third parties. The air carrier may make an advance payment to meet the immediate economic needs of the person entitled to claim compensation. In case of damage caused by the delay in the carriage by air of passengers, 5,346 special drawing rights, or approximately 6,650 euros. In case of destruction, loss of, or damage or delay to baggage, 1,288 special drawing rights, or approximately 1,602 euros per passenger. And lastly, in case of destruction, loss of, damage, or delay to cargo, 22 special drawing rights per kilogram, or approximately 27 euros per kilogram. That would be all for my report. Thank you for listening.